Hello everyone, a very good evening and welcome to the second marathon class of our BRBL CAIIB November-December 2024 session. And today we are going to cover the module B of our BRBL paper in one video. We are going to discuss MCQs covering each and every important topic from Module B, and Module B, which talks about the various acts and laws in the legal aspects of the banking operations. We are going to discuss the Prevention of Money Laundering Act, the Negotiable Instruments Act, the Payment and Settlement Systems Act, the FEMA Act. So all in all, this module is very important. These particular acts that we are going to discuss through the MCQs, we are not only going to discuss the question and answers, but also the complete revision, so that you can have your revision, you can do your revision in this class itself. So very quickly join the session and also share it with your other friends. Now let us start with the first question. Let us see what is the first question. The question is, which chapter in the PMLA deals with the obligations of the banking companies, financial institutions, and the intermediaries? So, the Prevention of Money Laundering Act. Under which chapter of this particular act of 2002 does the mention is given of the banking companies, financial institutions, and intermediaries, whether it is a chapter 1, chapter 4, chapter 6, or chapter 9? Answer this question. The Prevention of Money Laundering Act of 2002, basically to prevent the money laundering, to provide the for the confiscation of property that was involved in money laundering, right? So the persons that are indulging in money laundering in order to misuse the banking machinery. Which chapter includes the provision for banking companies and financial institutions in this particular act? The correct answer here is chapter 4. So chapter 4 of the act covers this. It was enacted to prevent money laundering and to provide for the confiscation of the property derived from or involved in the money laundering. It deals with the obligation of banking companies, financial institutions, and intermediaries. So, the central government, in consultation with the RBI, has framed the rules, that is, the prevention of money laundering, maintenance of records, and nature of the value of transactions, etc. Rules 2004. Accordingly, after the enactment of the Act in 2002, these rules were framed by the central government and RBI when in 2002. Moreover, the amendment that was made in 2012 has enlarged the definition of money laundering. So now this definition also includes activities such as concealment, acquisition, possession, and use of proceeds of crimes as criminal activities. Alright, so all the important information about the PMLA has been given here along with the answer. Make sure that you download the PDF and you go through all of this information, because questions can also be asked about the amendment of 2012, like what all has been included in the definition of money laundering, as well as the rules, when were they prepared, so in 2004. Okay, let's move on. For offences that are specified under paragraph 2 of part A of the schedule, what is the maximum term of imprisonment for money laundering? So under the act, in part A under paragraph 2, what term of imprisonment is given for money laundering? Option A says 7 years, B 8 years, C 9 years, or D 10 years. Answer this question. For the offence of money laundering, so under the section 4 of the act, it talks about whoever commits the offence of money laundering, they shall be punishable with rigorous imprisonment. Also, the paragraph 2 of part A talks about that this imprisonment, which was stated to be 10 years, that is, it can be extended to 10 years, right? So whoever commits the offense for money laundering shall be punishable. This is given in section 4 with rigorous imprisonment for a term which is not to be less than 3 years, but it can be extended to 7 years, shall also be liable to fine. So 3 to 7 years imprisonment plus fine. Also, the paragraph 2 of the Schedule A talks about the provision of this section shall have effect as if it may be extended to 7 years, which may be extended to 10 years. Alright. So, earlier when it was stated to 7 years, now it has been changed to 10 years. This is given in paragraph 2. If the question is going to ask you what is given in section 4, then you need to mention 3 to 7 years. But in paragraph 2 of part A, it is mentioned it is extended to 10 years. Alright, that is why the option D is correct. 10 years here is the correct answer. I hope this is clear. I hope you will remember what is given in the part A and what is given in section 4 regarding the imprisonment and fine. Alright, next question. Which of the following activities can make a person guilty of the offense of money laundering? We just said that the amendment of 2012, it included certain terms in the definition of money laundering. Accordingly, which of the activities are stated as offense of money laundering? And it is a multiple selection type question. So concealment, possession, projecting as untainted property, claiming as untainted property. Which of the following are correct? Whether 1, 2 and 3, 2, 3 and 4, 1 and 3 only, or all of the above, 1, 2, 3 and 4. Answer this question. Take 5 seconds and very quickly give me the answer. Under the money laundering activities, which of the following, if the person performs this activity, which of the following will be stated as guilty of money laundering? So let us see the correct answer. The correct answer is option D, that is 1, 2, 3 and 4, all of the above. A person shall be guilty of offense of money laundering if such person is found to be have directly or indirectly attempted or indulged to knowingly assisted or knowingly is a party or is actually involved in activities like concealment, possession, acquisition, use, projecting as untainted property or claiming as untainted property. Alright, so all of these activities will classify the person as guilty of money laundering. Second part, the process or activity connected with the proceeds of a crime is also continuing activity. If the person is using the proceeds of the crime and this person is directly or indirectly enjoying the proceeds of the crime, then also they will be treated as money laundering activities and they will be found guilty. Alright, so all of these activities are treated as the activities of money laundering. So concealment, possession, use, projecting, claiming as untainted property, even using the claims or of a proceeds of the crime. Next, which of the following are true about the maintenance of records under the PMLA? Which of the following statements are correct as to how records have to be maintained under the Prevention of Money Laundering Act? Information maintained must be kept confidential. Confidential means it should not be shared with the public. Records of identity documents must be maintained for 5 years after the business relationship end. The central government can exempt any reporting entity from obligation. Records of transactions must be maintained for 3 years from the date of transaction. So, regarding the maintenance of records as to how and till when the records have to be maintained, should the information be kept confidential or the identity documents have to be kept for 5 years even after the business relationship end? The government can exempt any reporting entity from this obligation of maintaining the records. or do they have to be kept for 3 years? The correct answer here is option A, that is 1, 2 and 3. So detailed information is given for the maintenance of records. And these maintenance of records, the obligations are given in chapter 4 of the Act of section 14 and 15. Oh, sorry, 12 to 15. From sections 12 to 15 in chapter 4. So every reporting entity shall maintain a record of all the transactions relating to the transactions covered in the clause B. Then they have to furnish this information within time as may be prescribed. The maintenance of the documents evidencing the identity of the clients and the business correspondence as well as the account files. Every information maintained or furnished shall be kept confidential so that no misuse of the information is made by a third party. The records referred to the clause A of the subsection 1 shall be maintained for 5 years from the date of transaction. So not 3 years but 5 years from the date of transactions. That is why the fourth statement is incorrect. And the central government may exempt any reporting entity or class of reporting entities from any obligation under this chapter, that is chapter 4. So 1, 2 and 3 are the correct statements regarding the records that are to be maintained under the PMLA. Clear? Why statement 4 is incorrect? Because it has to be maintained for 5 years. Okay. What protection is provided under section 14 of the PMLA to reporting entities and their officers? So we just said that from section 12 to 15, reporting, record, maintenance of document has to be done. So under section 14 of the Act, what protection is provided to the reporting entities and their officers? A. Immunity from civil proceedings. B. Immunity from criminal proceedings. C. Immunity from both civil and criminal proceedings. Or D. No immunity is provided to the entities and their officers. Which option is correct? Does the PMLA Act provide any protection to the reporting entities? Yes, it does, and it provides immunity from both civil and criminal proceedings. Every reporting agency shall, prior to the commencement of each specified transaction, so with the amendment in 2019, it resulted in the addition of section 12AA, which deals with enhanced due diligence. It deals with enhanced due diligence. All right. This particular section, it also states that no civil or criminal proceeding can lie against the reporting entity for furnishing information to the director. If the entity is providing, furnishing any information to the director, then this will not be considered as a breach of confidentiality and they will be provided immunity both from civil and criminal proceedings. This is mentioned in the section 14. So the correct answer is option C. Right? Okay. All of this is already given here. Next, which of the following must be recorded if a series of cash transactions integrally connected to each other exceed 10 lakh rupees within a month? So if a person or if any entity, they take or they make a cash transaction of exceeding 10 lakh rupees within a month, then which actions can be taken? All transactions individually valued below 10 lakh rupees, transactions that are made in a foreign currency, only transactions above 10 lakh rupees, and cash transactions involving the non-profit organizations. Which of the following must be recorded? Whether 1 and 2, 1, 2 and 3, 3 and 4, or 2, 3 and 4. So we have already seen that yes, records are to be maintained of all the transactions, the records of all the cash transaction of value more than 10 lakh rupees. So the correct answer here is A, that is 1 and 2. All transactions that are individually valued below 10 lakh rupees and transactions that are made in foreign currencies. Only transactions above 10 lakh rupees is incorrect, and involving non-profit organization is also incorrect. Okay. So every reporting entity shall maintain the record of all the transactions, including all cash transactions of value more than 10 lakh rupees or its equivalent in the foreign currency. Then the series of cash transactions integrally connected to each other which have been individually valued below rupees 10 lakh. So here what is mentioned in the question, transactions integrally connected to each other. So this is to be below 10 lakh rupees as mentioned here in the rule 3, right? All transactions involving receipts by a non-profit organization of value more than 10 lakh or equivalent in the foreign currency. And all cash transactions where forged or counterfeit currency notes or bank notes have been used. Okay, so these are the things that are mentioned in the rule 3 of the rules regarding the reporting or the records that have to be maintained. I hope it is clear. So when you study this chapter, when you're studying about the act, you need to go through all of this. Like records are to be maintained or reports are to be provided. All of these sections, all of these parts. That is why this paper is a bit complicated. You need to go into detail. What are the terms and conditions? What are the various components of each and every act? All right, and these type of questions were asked in the previous paper, the sections, the rules, the parts, the schedules. That is why we have to study in detail. So in what formats should the information about the transactions be maintained as per rule 6? So under the rule 6 of the act, in which format the rules or the information has to be provided? Whether they are to be provided only in hard copies, only in soft copies, both in hard and soft copies, or in any format as per convenience. We have seen that according to the rule 4, the records shall contain all the necessary information that is provided by the regulator, like the nature of the transactions, the amount of the transactions, the date on which the transaction was conducted, or the parties that are involved. And the rule 6 talks about the information as to the transaction which are to be maintained is the both in hard and soft copies. Both in hard and soft copies. Right? This information like the nature of the transaction, amount of transaction, currency in which it was denominated, the date of the transaction, the parties, both all of these information has to be maintained in both soft and hard copies as the manner that may be specified by RBI or SEBI. So the rule 4 talks about this information, and the rule 6 says that this transaction has to be maintained in the hard as well as soft copies. So both hard and soft copies, option C is correct. Next question. What constitutes a separate violation under the rule 8? So we are saying we are covering all the rules, all the sections of this PMLA act, so that you don't need to again open your book and read the chapter separately. You don't need to go word by word. Simply through these questions, you are revising all the topics. So what is considered as a separate violation under Rule 8, subsection 4? Delay of each date is not reporting a transaction. Delay of each day in rectifying a misreported transaction. Both 1 and 2, only if the delay exceeds a month. So if the reporting transaction is delayed by 1 day or reported transaction sees a delay of 1 day or it exceeds a month or both 1 and 2, which of the following will be considered as a separate violation? So under Rule 8, the correct answer is C, that delay of each day in not reporting a transaction as well as delay of each day in rectifying a misreported transaction. So the principal officer of a reporting agency shall furnish all the information referred to in the clauses of the sub-rule 1 of Rule 3 every month, and the principal officer of the reporting entity shall furnish the information. Here, for the purpose of this rule, delay of each day in not reporting a transaction or delay in making the misreported transaction correct or rectifying it will also be constituted as a separate violation. So here violations in the reporting have been mentioned, right? And then a separate violation is also mentioned if the person or if the bank makes a delay. Okay, information in respect of the transactions, the reporting or furnishing of the information, that should be done in not more than 7 working days. So the correct answer is both 1 and 2. Next question. Which documents are required for the verification of a company's identity? So for a company, if it has to provide verification of its identity, which documents are required? The certificate of incorporation, the memorandum and articles of association, registration certificate, and officially valid document in respect of the person operating the account, OVD. Which of the following are required if the company wants to verify its identity? 1, 2 and 3, 2, 3 and 4, 1, 2 and 4, and option D says 1 and 3 only. So which documents are required? Here the correct answer is C, 1, 2 and 4. Registration certificate is not required. For the individual, only the certified copy of the OVD containing details of the permanent address, current address including in respect of the nature of business and the financial status is required. So for the individual, OVD is enough. For a company, the certificate of incorporation, memorandum and articles of association, board resolution or the power of attorney, OVD recorded in respect of the person operating the account, registration certificate is not required. For a partnership firm, the registration certificate is required for the partnership firm. And the partnership deed, OVD. For a trust, the registration certificate again is required. The trust deed, OVD. And for the unincorporated association, the resolution of the managing body, power of attorney granted to the person, information as may be required by the banking company to establish the legal existence. So here all the entities are mentioned. If they want to verify their identity, these are the documents that they need to furnish. So for a company, the registration certificate is not required. All the other things 1, 2 and 4 are required to be furnished. All right. Next, what was the sentence given to Arun Mukherjee in the Rose Valley money laundering case? So this is a very popular case. This can also be asked as a case study question. So there are various convictions. We have studied about the various cases like the Rose Valley money laundering case, then the Galaxy Impex money laundering case, the drug related Hari Narayan Rai. So here the question is asking, as a case study type question, what was the sentence given? 5 years imprisonment and a fine of rupees 1 lakh, 7 years imprisonment and a fine of rupees 2.5 lakhs, 10 years imprisonment and a fine of rupees 5 lakhs, or 3 years imprisonment and a fine of rupees 1.5 lakhs. What was the sentence given in this particular case? So a special PMLA court was held in Kolkata which convicted a Rose Valley official, Arun Mukherjee, in the money laundering case, and the sentence that was given to him was 7-year imprisonment plus a 2.5 lakh rupees fine. So here the complete case is given. The alleged was that Rose Valley Estate Construction Limited and its associate companies, they repeatedly floated secured non-convertible debentures in several years and issued to more than 49 persons in each financial year. They illegally raised 12.82 crores from over 2,500 persons. Then the proceeds that were raised from these criminal acts were reinvested in various movable properties. So the PMLA fixed deposits of 12 lakhs were attached. So various accused persons were given. They were arrested in 2015 under this particular case. So 7-year imprisonment and a fine of 2.5 lakhs. You need to study these particular cases. Why? Because case study type questions can be asked from these. Next, if the drawer of a check is acquitted, what actions must the court take? Okay. So now we are talking about the Negotiable Instruments Act of 1881. So under the act, if the drawer of the check is acquitted, what actions must the court take? Direct the complainant to repay the amount of interim compensation, include interest at the bank rate as published by the RBI, provide a repayment period of 30 days, allow an extended repayment period of up to 30 days if sufficient cause is shown. What are the actions that the court can take if the drawer of the check is acquitted? Which of the following are correct? Yes, the correct answer here is option A, 1, 2 and 4. 1, 2 and 4. Full complete information is provided to you in this PDF with the insertion of section 143A. In the particular act, the new provision was introduced where a competent court, while trying a check dishonor offense, is empowered to order the drawer of the check to pay interim compensation not exceeding 20% of the check amount. So the court can direct the complainant to repay the amount of interim compensation. Right? What else can the court do? They can also, they have to be, this compensation has to be paid within a prescribed time period of 60 days, the date of the passing of the court order, with the extended period of 30 days. So here repayment period of 60 days is given. It should be 30 days is given, it should be 60 days extended to more 30 days, right? And what else? Interest can be included and allowed an extended repayment of 30 days. So 1, 2 and 4 is correct and statement 3 is incorrect. Here the repayment period of 60 days is to be provided. Alright, so the correct answer is option A, 1, 2 and 4. Next, who bears the burden of proving that the holder of a negotiable instrument is not a holder in due course if the instrument was obtained through fraud or unlawful means? So under this Negotiable Instruments Act, if any instrument was obtained through fraud or unlawful means, then who is going to bear the burden of proving that the holder of the negotiable instrument is not the holder? This burden is borne either by the holder or the maker of the instrument, the person from whom the instrument was obtained, or option D, the lawful owner of the instrument. Who has the responsibility to prove? So here the correct answer will be option A, that is the holder. The holder. So herein the holder is a holder in the due course, holder of the negotiable instrument in the due course where the instrument has been obtained from its lawful owner or from any person who has the lawful custody by the means of an offense or fraud. So they need to provide the proof that the holder is in the due course. Okay. So this is under section 118. Every negotiable instrument was made or drawn for consideration. Every such instrument, when it has been accepted, endorsed, was accepted or transferred for consideration. So go through this information. So who has the responsibility to prove that the negotiable instrument is not a holder in due course? The correct answer is the holder itself has to make this proof, has to provide this proof. Okay. Next question. Which of the following is not an essential characteristic of a bill of exchange? So we know what is a bill of exchange. We know the characteristics of a bill of exchange. Which of the following is not an essential characteristic? That it must be in writing. It must be signed by the drawer. The drawer, drawee and payee must be certain. It must be endorsed by the payee. So the bill of exchange, which is defined under section 5, instrument under the Negotiable Instruments Act. The essential characteristics of the bill of exchange, as we know, is that it must be in writing, that it must be signed by the drawer, drawee and payee must be certain, the sum payable must also be certain, it should be properly stamped, and it should also contain an express order. These are the essential characteristics. So, it must be endorsed by the payee is not a characteristic of the bill of exchange. So, section 5 describes a bill of exchange and instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or to the order of a certain person. The terms that are given in the law are a bit complicated because they are given in the exact law terms, so it might be a bit confusing, but we can still remember the facts. We can still remember these characteristics of the bill of exchange, right? So it should not, it is not a compulsion that it should be endorsed by the payee, but it should be properly stamped. It must contain an express order to pay money, that the person will pay the money to the given person, the drawer, drawee and the payee relationship. So the correct answer is option D. Next, which of the following instruments requires the notice of dishonor? Here, according to the differences that are given, the difference between bill of exchange and check, which of the following instruments require the notice of dishonor? Check, bill of exchange, both check and bill of exchange, or neither check nor bill of exchange? Which of the following are correct? Using this information that I've mentioned here, you can easily answer this question. The bill of exchange can be drawn on a person, firm, or etc. Check is always drawn on a bank. The bill of exchange may require acceptance, but check, no acceptance is required. The bill of exchange is payable on demand or after a certain period, but the check is always payable on demand. Bill of exchange may have a grace period, which the check does not. Notice of dishonor is required in the bill of exchange, but no notice of dishonor is required in the check. So the correct answer is option B. Only the bill of exchange requires a notice of dishonor. The check can be crossed, bill of exchange cannot. No stamping is required in the check, may require stamping in the bill of exchange. The bill of exchange cannot be drawn payable to the bearer. On the other hand, the check can be. And under the bill of exchange, the payment cannot be countermanded by the drawer, whereas in the check, this can be done. Alright, so the correct answer is bill of exchange requires a notice of dishonor and the check does not. Next question. Choose the correct statements about a drawee in the case of need. So under this particular act, which of the following statements are correct about the drawee in the case of need. We have the definitions given in section 7, which defines the drawer, the drawee in case of need, the acceptor for honor, and the pay. All these definitions are given under the section 7 of the Act. So, which of the following statements are correct about the drawee? It is a person who is to be resorted to in case of need. It is the original drawee of the bill. The name is given in the bill or any endorsement thereon. It is a person designated by the drawer to pay the bill directly. Which of the following statements are correct according to the section 7 of our Negotiable Instruments Act? So, the correct answer is A and C only. A and C only. Drawer, the definition of drawer is the maker of a bill of exchange or the check. That is the person thereby directed to pay is called the drawee. Alright. Drawee, what is the definition of drawee? The person who is directed to pay. And drawer is the maker of the bill. Alright. Drawee in case of need is when a bill or in any endorsement, the name of any person is given in addition to the drawee. If resorted in the case that the drawee does not make the payment, then the drawee in case of need is mentioned. It is a person who can be resorted whenever required, and it is the name given in the bill or any other endorsement thereon. Acceptor is the after the drawee of the bill has signed his assent upon the bill. If there are more parts thereof than when, then upon one of such parts and delivered the same or given notice of such signing to the holder or some person on his behalf is known as the acceptor. The acceptor on behalf of the drawee. An acceptor for honor definition is also given, who is going to accept the protest for honor of the drawer or of any of the endorsers. And pay is the person to whom or to whose the order of money is directed to be paid is known as the pay. Alright, so A and C are correct about the definition of the drawee in case of need as per the Act under section 7. Right? Next, select all the correct statements about the protection given to a paying banker under section 85. So under section 85 of the Act, what protection is given to the paying banker? So a paying banker is protected against fraudulent endorsements of the pay. A paying banker is protected only if the endorsement is genuine. A paying banker is protected if the payment is made in due course. Or a paying banker is always liable for fraudulent endorsement. Is it the responsibility of the paying banker, if the endorsement of the pay are fraudulent, or are they provided um, protection if the payment is made in due course? Which of the following statements are correct? This is provided under section 85 that 1 and 3 only. 1 and 3 only under the Negotiable Instrument Act, that additional protection to the paying banker is available against fraudulent endorsements of the payee or other endorsees. So if the payee or the endorsees, they make a fraudulent transaction, so the paying banker will be provided additional protection. Where a check payable to the order purports to be endorsed by or on behalf of the payee is discharged by payment in due course, then also the banker will be provided protection. So the correct answer is 1 and 3 only. 1 and 3 only. The paying banker is not always liable for fraudulent endorsement. They are provided protection or additional protection. Then choose the incorrect statements about the instances of material alteration in a check. So we can make some changes in the check, it is provided, but regarding the material alteration of a negotiable instrument like a check, which of the following statement is incorrect? Alteration in the date of the instrument can hasten or delay the time of payment. Alteration of the amount is the most common form of fraudulent alteration. Alteration of the name of the payee does not count as the material alteration. Alteration of an order check to a bearer check is a form of material alteration. So, any alteration can be material which actually alters the business effect. That is why it is known as the material. If it is altering the business effect of an instrument which is used for the business purpose. So, if any change is made which the different language in the legal terms is used than which was used in the original transaction or in the original check, it will be considered as a material alteration. So the correct answer here is C, or we can say the incorrect statement is C, that the alteration of the name does not count as material alteration. The following instances of material alteration can be considered important. Alteration in the date of the instrument, which might have the effect of hastening or delaying the time of payment. Alteration of the name of the payee or the beneficiary is also material alteration. Alteration of the amount, which is the most common form of the fraudulent alteration, and alteration of an order check to a bearer check. So the name change, any alteration is made in the name of the payee, will be counted or will be included as a material change. Alright, so the correct answer is option C. Next, in which case does section 89 provide protection to the paying banker? Again, we are talking about the paying banker, the protection that is provided to them, but now we are talking not about the section 85 but section 89. Option A, when the alteration is apparent. B, when the alteration is not apparent. C, when the check is not crossed. D, when the check is issued without a date. So, the section 89 deals with the cases where the payment is made by the bank which was forced by alterations that are not apparent. Right? So the correct answer here is option B, that is where the alteration is not apparent. If the change that is made in the negotiable instrument is not very clear, it is not very apparent, then it will be provided. The paying bank will be provided protection. Like for example, amended section where a promissory note, bill of exchange or check has been materially altered, but it does not appear to have been so altered that the person is trying to hide the alteration. Then the banker will be provided protection. Where the check is in an electronic image of a truncated check and it is any difference is seen in the apparent tenor. Alright, so herein the paying banker will be provided protection under section 89. Next question. What can a holder do to an open check according to the decided cases? What options are provided to the holder of the check according to the decided cases? They can cross the open check, they can add the word not negotiable to the crossing, they can obtain a duplicate of a lost bill, or all of the above. The holder of the check, what options are available? The holder or the holder in the due course and the holder for the value. Any negotiable instrument. So the correct answer, if they are having an open check, the correct answer is D. All of the given options are available. They can cross the open check, they can add the word not negotiable, and they can also obtain a duplicate of the lost bill. Alright, so where the bill or the check is lost or destroyed, then its holder is the person so entitled at the time of such loss or destruction. So the person should be entitled in his or her own name to the possession of the instrument. For example, a finder of a lost instrument cannot be called a holder. Only the person whose name is there on the instrument can be said to be the holder, not if a person who finds a lost check. Alright, so the holder can cross the open check, they can add the word non-negotiable, and they can also obtain a duplicate of a lost bill. So the correct answer is all of the above, and this is given in the section 8 of the Negotiable Instruments Act. Next question. What constitutes an offence under section 138 of the Negotiable Instruments Act when a check is returned unpaid? So if a check is returned unpaid, then what is constituted as an offence under the NI Act? Option A, the check is returned due to insufficient funds in the account. B, the check is presented after 6 months from the date it was drawn. C, the check is returned due to the drawer's instructions. Or D, the check is presented within 3 months from the date that it was drawn. So which of the following will be considered as an offence? When the check, if the bank returns the check unpaid, then which of the following will be considered as an offence? So the correct answer is option A, that the check is returned, if the check is returned due to insufficient funds in the account, then it will be considered as an offence. So if any check that is drawn by a person on an account that is maintained by them with a banker for the payment, and if they do not have sufficient fund to honor the check, then it exceeds the amount that is arranged to be paid from that account, then the person shall be deemed to have committed an offence. That is, if let's say a person signs a check of certain amount, but that amount is not there in the bank account of the person, so this will be considered as an offence committed by them. All right. So the correct answer is option A. Option A. Next, identify the true statements about a current account transaction. Which of the following statements are correct about a current account transactions? It includes payments due as interest on loans. It involves changes in the assets or liabilities outside India. It includes the remittances for living expenses of family members residing abroad. It includes the expenses in connection with foreign travel, education, and medical care of the family members. So now we are talking about the FEMA Act, the Foreign Exchange Management Act, which was earlier known as the FERA, the Foreign Exchange Regulation Act, originally that was passed in 1973. It was renamed as the FEMA Act in 1999. So take 10 seconds and try to answer this question. Yes, so under the FEMA Act, various definitions are given, like what is the authorized person, what constitutes as the capital account transaction, as well as the current account transaction, currency, foreign currency, security. And as per the FEMA Act, the current account transaction includes option B, that is A, C, and D. A, C, and D. So if we see here, yes, current account transaction, payments due with respect of foreign trade done, other business services, short-term banking and credit facilities, payments due as interest on loans, remittances for living expenses of parents, spouse and children residing abroad, expenses in connection with foreign travel, education and medical care. But it does not include the changes in the assets or liabilities outside India. Alright, so A, C and D. Other definitions, what is the definition of authorized person? What all is included in the capital account transaction? How is currency defined? It will include not only the currency notes but also postal notes, orders, money orders, checks, drafts and so on. Alright, so the correct answer is option second, that is A, C and D. Next, select the incorrect statements about a person resident in India. So the FEMA defines a person that is resident in India. Which of the following are is incorrect about that definition? Option A, a person who has resided in India for more than 182 days, that is 182 days in the preceding financial year. A person who has gone out of India for taking up employment is considered as a resident in India. A person corporate registered or incorporated in India is considered as a resident in India. An office, branch or agency owned or controlled by a person resident outside India. Out of these, three are correct about the person resident in India and one is incorrect. One definition does not define the person resident in India correctly. So, which of the following are incorrect? The correct answer here is option B. The person who has gone outside of India for taking up employment is not considered a resident in India. Alright? Is not considered a resident in India. So, a person who is residing in India for more than 182 days will be considered, but it does not include a person who has gone out of India or who stay outside India. They have taken employment outside India for carrying on business or vocation for any other person, right? Okay, so all the definitions of a person resident in India is given here. A person who has come to India or stay in India otherwise, taking up employment in India, then person or body corporate registered or incorporated in India, these will be included as the person resident in India. But if they move out of India for taking up employment, then they will not be considered as a resident in India. Resident means you're residing in India. You are living in India. Alright? Also your if you are living in India or your activity of employment through which you are generating income, that is to be in India. Okay. Select the correct statements about the right of persons that are resident outside India. So persons resident outside India, what rights do they have? They cannot hold foreign currency. They can invest in foreign currencies. They can own immovable property outside India, or they must repatriate any assets to India. If they have any asset, they have to repatriate, right? Or they can hold immovable property, they can invest in foreign currency, or they cannot hold foreign currency of the persons that are resident outside India. Which of the following statements are correct about the persons who are resident outside of India? Answer this question. Yes. So the correct answer here is option D, 2 and 3 only. They can hold foreign currency and they do not need to repatriate any property or any asset that they hold outside India. It is not compulsory that they have to send it to India. So 2 and 3 only are correct. Okay. So where any person in or resident in India receives any payment by an order or behalf of any person that's a resident outside India without a corresponding inward remittance, or we are here talking about the one way transfers. One way transfers. Okay, so the correct answer is D, 2 and 3 only. Next, Which rank must officers be above to be authorized to investigate under section 37? So under section 37 investigation is allowed. Now these investigating officers are to be from a particular rank. They should be at least above a particular rank to investigate under section 37. Which of the following is the correct rank? Under secretary, assistant director, director or deputy secretary? So yes, the central government establishes a directorate of enforcement under the section 36, and under the section 37 it talks about that any class of officers in the central government, state government or RBI not below the rank of an under secretary are allowed to investigate. So a directorate of enforcement is established under 36, which is called the officers of enforcement, the power of search, seizure, etc. Then section 37 talks about that the central government can authorize any class of officers, central state government of RBI not below the rank of under secretary. And section 38 says that the central government can authorize any customs officer or central excise officer, any police officer to exercise the powers and discharge the duties of the director of enforcement. So these three sections, 36, 37 and 38 talk about the Directorate of Enforcement under the Act. Alright. So the correct answer is option A, under secretary. Next, what is the exception for seizure under the section 37A? So section 37A talks about the special provisions that are relating to the assets that are held by people outside India. So it deals with the cases where the Indian citizens, in contravention of the section 4, the holding of foreign exchange. So which of the following is correct? If the aggregate value of the foreign assets is more than the prescribed value, sorry, if the aggregate value of the foreign assets is less than the prescribed value, if the assets are held for personal use, if the assets are held temporarily. So what exception is provided that the asset will not be seized under section 37A? Yes, the correct answer is option B, that if the aggregate value of the foreign asset is less than the prescribed value. So section 37A, it deals with the cases where the assets are held abroad by an Indian citizen in contravention of section 4. Section 4 states holding of foreign assets save as otherwise provided in that act that no person resident in India shall acquire, hold, own, possess or transfer any foreign exchange, foreign security situated outside India. Alright, so if information is received, then the authorized officer that is prescribed by the central government and they have a reason to believe that the foreign exchange is in contravention of the section 4, then they can seize the value equivalent that is situated in India. Alright, but the exception is provided that the foreign assets is less than the prescribed value, then this seizure will not be done. So the correct answer is option B. Next, within what period must the competent authority dispose of a petition regarding the seizure under section 37A? So what is the period exceeding which this petition will be disposed of? 90 days, 180 days, 240 days or 360 days under section 37A. Which of the following is correct? The correct answer here is option B, that is 180 days. So, in order of the competent authority confirming seizure of the equivalent asset shall continue till the disposal of the adjudication proceedings, and thereafter the adjudicating authority shall pass appropriate directions with regard to the further action. Right? So, if 180 days time period has been done, extended, then the competent authority can dispose of a petition. So the competent authority will dispose of the petition within a period of 180 days from the date of the seizure by either confirming or setting aside such order after giving an opportunity of being heard. Right, so if the person that is living outside India, they possess the property and the competent authority says that we are going to make a seizure and they make a petition, so it has to be done within 180 days, 180 days. Right, so FEMA Act has all of these sections, subsections under it. Then next act under this particular module is the Payment and Settlement Systems Act. First question of this particular act says, choose the correct statements about the instruments that are considered as derivatives under section 2, 1 subsection B. The interest rate swaps are included. The forward rate agreements are not included. The foreign currency options are included. The promissory notes are included. Which of the following are included as derivatives under this particular act? The Payment and Settlement Systems Act of 2007, the correct answer is option B. Derivative is going to mean an instrument to be settled at a future date whose value is derived from change in the interest rate, foreign exchange rate, credit rating or the credit agency, price of securities or any other underlying combination includes the interest rate swaps, forward rate agreements, foreign currency swaps, foreign currency rupee swaps, foreign currency options, foreign currency rupee options, or any other instrument that is specified by the Reserve Bank. Right? So the correct answer is B. Then select the incorrect statement about the scope of netting. Which of the following statements are incorrect about netting? Netting applies to both payment and delivery obligations among the system participants. Netting does not include claims arising from the dissolution of a system participant. Netting is specified in the rules or regulations or the bylaws of the system provider. Netting is applicable only for transactions admitted for the settlement at a future date. So, regarding netting, which of the following is incorrect? So, we already know what is the meaning of settlement and netting. I hope settlement is the process of transferring of funds to a central agency. We can say from the payer to the payee, right? So the incorrect statement accordingly will be B, that netting does not include claims arising from the dissolution of a system participant. The correct statement is it will include. So netting means the determination by the system provider of the amount of the money or securities due or payable or deliverable as a result of setting off or adjusting the payment obligations. So what is the meaning of netting? It means that the amount or the money that is provided or the payment obligations as a result of setting off or adjusting on the insolvency or dissolution or winding up of the system participant. Alright, so the correct answer is option B, that netting does not include claims arising from dissolution. It does. It is mentioned right here. It will include the claims arising from insolvency or dissolution or winding up of any system participant. Alright, so netting does apply to both payment and delivery obligations specified in the rules or regulations, applicable for transactions admitted for settlement at a future date. All of this is mentioned right here. Next question. Which of the following is exempt from the provisions of Section 4 of the Payment and Settlement Systems Act 2007? So the Section 4 of the Payment and Settlement Act, which of the following are made exempt? Any individual acting independently, a company accepting payments from its holding company, foreign banks operating in India, or any person operating a payment system without RBI authorization. So which of the following will be exempt from the section 4? The correct answer is B. The Payment and Settlement Systems Act extends to the whole of India. It extends to the whole of India, provides for the regulation and supervision of the payment and settlement system in India, and designates the Reserve Bank of India as the authority for that purpose. So RBI is authorized to act under the act to constitute a committee of its central board known for the Board of Regulation to exercise the powers and perform its functions. Yes. Next question. Which of the following is a condition that an authorization issued under subsection 1 of the Payment and Settlement Act must state? The subsection 1 of the Act must state which of the following condition? The name of the payment system operator, the date on which the authorization takes effect, the address of the payment system operator, or the duration of the authorization. So under the subsection 1, which of the following information has to be provided? So the information for the authorization under the subsection 1 that has to be provided is the date on which the authorization takes place. So the date on which it takes place, the condition subject to which the authorization shall be enforced, to indicate the payment of fees, if any. If it considered necessary, then it might require the applicant to furnish such security for the proper conduct and continue to be enforced till the authorization is revoked. All of these things will be mentioned for the authorization issued under subsection 1. Right? So the correct answer is option B. Next, according to section 14 of the Act, which statements are true regarding the inspection powers of Reserve Bank? So, RBI has been given, the central bank has been given the power to supervise, monitor and conduct inspection. Under that power, which of the following are true? Any officer of the Reserve Bank can enter premises without written authorization. The officer can inspect any equipment including the computer systems. The officer can call upon the employee to furnish information or documents. Inspections can only be carried out during the business hours. Which of the following are true regarding the inspection that is conducted by Reserve Bank? So this is dealt under the section 12, section 13 and 14, that the officer can inspect any equipment and the officer can call upon any employee. It is not necessary that the inspection should be carried only during the business hours. Neither any officer can enter the premises without written authorization. So written authorization is required. So the Reserve Bank may call from any system provider the returns or documents. This is under section 12. Then under section 13, they have the right to access any information. Under section 14, the Reserve Bank duly authorized officer, not any officer, but the officer that is duly authorized will conduct the inspection. Okay? And they can conduct the inspection anytime during the premises or after that also. So the correct answer is option C, that is 2 and 3 only. Next, what happens to a settlement effected under the procedure indicated in the rules for the operation of a payment system? So if a settlement that is effected under the procedure given in the payment system, what will happen? Whether it is final and irrevocable, or it can be revoked at any time, or it requires further approval from the court, or option D, it is subject to review by the participants. Which of the following statements are correct if a settlement is done according to the rules? The correct answer is that it is final and irrevocable. It cannot be revoked, it does not require approval, or it is not subject to review by the participants. So when an order of a court or tribunal or authority is made that a system participant is declared as insolvent, or a liquidator receives or receiver or assignee is appointed in a proceeding related to insolvency, then such decision, such settlement will be final and irrevocable. It cannot be further reviewed, or it cannot be revoked at any time, or it does not require further approval from the court if it is made according to the rules for the operation of a payment system. Alright? So it will become final and irrevocable under the Insolvency and Bankruptcy Code 2016. Next question. Which sections of the Payment and Settlement Act grant the Reserve Bank of India the power to impose penalties on the system providers? So RBI does have the power to impose penalties. This power is granted under which sections of the Act? Option A, sections 20 and 21. Option B, section 22 and 23. C, 30 and 31. Or D, section 32 and 33. Right. So the correct answer, I hope you would have answered it. The correct answer here is C, under section 30 and 31. Powers are available with RBI to impose penalties on the system providers or banks for flouting, countervening positions or default. These are given under section 30 and 31. Alright, under section 30 and 31. Then under section 38, separate instructions are given. The RBI may make regulations consistent with that act without prejudice. The powers and functions referred to are given in subsection 2 of section 38. All the sections are given here regarding the penalties that RBI can impose. So the sections, the penalties, if imposed by RBI, all of this becomes important. In the previous session also, questions from sections and penalties were asked. So make sure that you do go through these sections and penalties if any. Alright. Next, what is transferred defined as a mortgage under section 58A subsection of the Transfer of Property Act 1882. So now we are moving on to the next act, the Transfer of Property Act 1882, definition of mortgage is given. Which of the following is correct? Transfer of ownership of property, transfer of interest in specific immovable property, transfer of movable property, or transfer of tenancy rights. So now we are talking about the laws that are relating to the securities and modes of charge, under which first act that we have is the Transfer of Property Act. So a mortgage is defined as a transfer of interest in specific immovable property. Specific immovable property. Mortgage is a transfer of interest in the specific immovable property for the purpose of securing the payment of money that is advanced or is to be advanced by a way of loans in the future or the existing debt. So the transferor who is making the transfer is known as the mortgager, and the transferee is the mortgagee. Alright, these terms you should know. Question might be asked like who is known as the mortgager, so you should know it is the transferor making the transfer of interest. What are the ingredients of a mortgage? There should be a transfer of interest in the property by the mortgager who is the owner or the lessor, and the transfer should be to secure money paid, that is to be paid by the way of loan. So the correct answer is transfer of interest of immovable property. Next, which statements are true about the features of a simple mortgage? So different types of mortgages are there. Simple mortgage, mortgage by conditional sale, the English mortgage, anomalous mortgages are there. So which of the following is correct about the simple mortgage? The mortgagee has no power to sell the property without the intervention of the court. The mortgagee is entitled to payments out of the rents and produce of the mortgaged property. The mortgagee is not put in possession of the property, and D says registration is mandatory if the principal amount secured is rupees 100 and above. So which of the following are correct about the simple mortgage? Simple mortgage, again according to the definition given in section 58B, whereby without delivering the possession of the mortgaged property, the mortgager is binding himself personally to pay the money. Right? They are not delivering possession of the mortgaged property. That is a simple mortgage. So the features accordingly are 1, 3 and 4. 1, 3 and 4. The mortgagee has no power to sell the property without intervention because the mortgager is not making the actual transfer of property. Then the mortgagee has no right to get any payments out of the rents. The mortgagee is not put in possession of the property, and registration is mandatory if the amount secured is 100 and above. So this is a very important topic. You need to know the different features of a simple mortgage or the mortgage by conditional sale, English mortgage, and so on. Right? Next question. Under the mortgage by a way of conditional sale, which of the following statements are true? This is the second type of mortgage that is defined under the Act. So the sale becomes void on repayment of the mortgage money. The mortgagee can look to other properties of the mortgager for repayment. The sale shall become absolute upon the non-payment and a court decree is in favor of the mortgagee. The bankers prefer this type of mortgage due to its simplicity. So which of the following are characteristics of a conditional sale mortgage? So which type of conditions can arise? If there is a default of the payment or on such payment being made, the sale shall become void. How the buyer can transfer the property to the seller, right? So whereby the mortgager, they sell the mortgage property. What conditions are required? So the correct answer is option A. 1 and 3 only, that the sale will become void on repayment of the mortgage money. The mortgager will not sell it if the mortgage money is paid, and the sale shall become absolute upon non-payment and a court decree. If non-payment is done, then it will become absolute. So two conditions are there. Either it will become void or it will become absolute. So the sale is ostensible and not real. Only if the money is not repaid on the agreed date, that the sale will become absolute, right? The mortgage, the mortgagee can sue for the foreclosure, but they cannot sell off the property. They can sue the person in the court, but they cannot themselves sell off the property. There is no personal covenant for repayment of the debt, and therefore bankers do not prefer this type of mortgage. It is a conditional sale. It is not a very sure shot agreement, we might say. So the bankers, they do not prefer this type of mortgage. It is not simple, it is very complicated. All right. So the correct answer is 1 and 3 are the characteristics of a conditional mortgage. All right. Next, what happens to a property under the English mortgage? So we have covered questions from all the types of mortgages. What will happen to the property under the English mortgage if the mortgage money is repaid as agreed? The mortgagee retains the property. The mortgagee transfers the property to a third party. The property is reconveyed to the mortgager, or the property is sold at auction. So in the case of an English mortgage, what will happen if the mortgage money is repaid as agreed in the earlier contract, in the original contract? So if it is repaid, then the property is reconveyed to the mortgager. So if the mortgager binds himself to the repay, this we are talking about the English mortgage, and the repay is to be done on a certain date, but it is subject to the provision that he will retransfer it to the mortgager upon repayment of the mortgage money. So it provides for a personal covenant to pay on a specified date. There is an absolute transfer of the property. However, this absolute transfer is subject that the property shall be reconveyed to the mortgager. If the repayment of the mortgage money is done, then it will be reconveyed, and the mortgagee can sue the mortgager for the recovery of the money, and they can obtain a decree for the sale. If the mortgager sells off, then the mortgagee can also recover the money. All right. So the correct answer is option C. Next, which statements are true about the creation of a mortgage by the deposit of title deeds? This is another type of mortgage, by the deposit of title deeds. So there must be a debt, there must be a deposit of title deeds, there must be an intention that the deeds shall act as security for the debt, or the mortgagee must possess the property. Which of the following are characteristics of the creation of mortgage by deposit of title deeds? Whether 1, 2 and 3, 2 and 4, 1 and 3, or 1, 2, 3 and 4. Which of the following statements are correct about the mortgagee by deposit of deeds? So, where a person in particular towns are mentioned like Kolkata, Chennai and Mumbai, they deliver a creditor or his agent documents the title to an immovable property, then we can say it is a mortgage by deposit of title deed. So particular cities are mentioned: Kolkata, Chennai and Mumbai. Then under this, the correct answer will be A, that is 1, 2 and 3. The documents of title or title deed in case of the mortgage by deposit of title deeds is created, right? And the essential features are that such a mortgage can be affected only the towns that are specified. Towns are Kolkata, Chennai and Mumbai. Only in these specified towns notified by the state government that the mortgage can be affected. Then to create this mortgage, there must be three ingredients. There should be a debt, there should be a deposit of title deeds, and an intention that the deeds shall act as security. But the mortgager must possess the property is not a pre-requirement. Next, which statements are true about the essential features of an anomalous mortgage? So, another type of mortgage, anomalous mortgage. Which of the following are true about its essential features? It must be a mortgage as defined by Section 58 of the Transfer of Property Act. It is positively defined as one of the listed types of mortgages. It is usually a combination of the two mortgages. It does not involve any transfer of interest in the property. So now we are talking about the anomalous. A mortgage which is not a simple mortgage, or a mortgage by conditional sale, or a mortgage by the English mortgage deposit of deed, then it is called an anomalous. It is not any of the type. And basically we are talking about it is a combination of two mortgages. It is not a separate mortgage. So the correct answer will be option B, 1 and 3 only. It is not a listed type of mortgage and it does involve the transfer of interest in the property. So 1 and 3 are correct. So it must be a mortgage as defined in Section 58. That is the given mortgages that we discussed earlier. And it should be a combination, for example, a simple and usufructory mortgage or conditional stage combination. What are the merits and demerits? Normally, the borrower saves the stamp duty on the mortgage deed and the registration charges, and it also involves minimum formalities. So, it is a cost effective method of mortgage. It is also less time consuming and it is more convenient. It can be done without much publicity and therefore the customer's position is not exposed to the public gaze. Alright, so these are all the characteristics, benefits of the anomalous mortgage. Next, according to the Section 47 of the Registration Act 1908, when does a registered document operate? So now we are talking about the Registration Act of 1908, and according to 47, Section 47, when does a registered document operate? From the date of its registration, from the date it is presented in court, from the time of its execution, or from the date of its notarization. So, under the Registration Act 1908, which of the following is correct? The correct answer is option C, from the time of its execution. So, Indian law on priorities is provided in Section 48 of the Transfer of Property Act, and the Section 47 of the Registration Act. It states that the registered documents operate not from the date of its registration but from the time of its execution. It is very clearly mentioned in this act that the registered document is going to operate from the date of its execution, not from the date that it is registered, right? Other things that are mentioned in the act are given here. You can go through them. What are the exceptions related to that? What are the exceptions in the recognition in the Indian system? How the immovable property is dealt with? All of these things are mentioned in the act. Next, what are the popular types of mortgages that are obtained by the banker? Bankers, they prefer which type of mortgages? The usufructuary mortgage, conditional mortgage, mortgage by deposit of deeds. B, mortgage by deposit of deeds, simple mortgage in English. English mortgage which of the following are preferred by the banker? So the correct answer here is option B, mortgage by the deposits of title deeds, simple mortgage and English mortgage. These are the popular types of mortgages that are obtained by the banker. So enforcement of all of these type of mortgages is by the way of filing a suit for the sale of a mortgage property. This filing of suit can be done under the Code of Civil Procedure 1908. Under section 16 subsection C, the sale of mortgage property shall be filed in the court. Order 34 says that for various things adhering to the filing of suit for the sale of mortgage property, this can be done. So the popular ones are mortgage by deposit of title deeds, simple mortgage and English mortgage. Conditional mortgage or usufructuary mortgage, these are avoided by the banks. Next, which statements are true about the rules of appropriation under the Indian Contracts Act 1872? Under the Indian Contracts Act 1872, which of the following statements are correct about the rules of appropriation? A creditor may apply any payment received to any debt that they choose. A payment must be applied to the specific debt that is indicated by the debtor. The debtor must always specify the debt for which the payment is being made. The payment can be made to any debt if no specific debt is indicated by the debtor. So, under the Indian Contracts Act, the rules for appropriation are given as to who receives the payment from the debtor and where the debtor and creditor are involved, appropriation, what is the meaning of appropriation, all of these things are given. So here the correct answer will be option D, that is 2 and 4. 2 and 4 statement are correct. Appropriation is the application of a particular payment received from a debtor for the purpose of repayment of a particular debt. This is known as appropriation. Basically, setting aside of the funds, that is applying the funds received from a debtor for paying a specific debt. So if the debtor wants to pay, they have to pay a specific debt, and they, for that purpose, they're keeping aside funds. That is appropriation. So herein the application will be made where the debt is discharged, indicated where a debtor owing several distinct debts to one person makes a payment to him either with express intimation or under circumstances that are implying that the payment is to be made, it must be applied accordingly. So either they will specifically tell this that the payment is made to a specific debt indicator, or it is applied to any debt if no specific debt is indicated. Alright, so the correct answer is 2 and 4. Next, which of the following is not applicable under the Transfer of Property Act? Under the Transfer of Property Act, which of the following is not applicable? The transfer of a marine policy of insurance, the transfer of a fire policy of insurance, the transfer of debt or other actionable claims, the transfer of rights to sue or institute proceedings. Which of the following cannot be made under the Transfer of Property Act? So the correct answer here is option A, that is transfer of a marine policy of insurance. So the Transfer of Property Act states that providing that every dealing with the debt or other actionable claim by the debtor or any other person from or against whom the transfer would be made, or any such instrument where the transfer is to be made, This shall be applied, but nothing in this section applies to the transfer of a marine or fire policy of insurance. Alright, marine or fire policy of insurance. So the correct answer is option A. Or if it affects the provisions of section 38 of the Insurance Act. It will apply on the execution of instrument of transfer, sue or institute proceedings with or without obtaining the transferor's consent. Next question. What does section 132 of the Transfer of Property Act 1882 state about the rights of an assignee? What rights do the assignee have under section 132 of the Transfer of Property Act? An assignee has the rights greater than those of the assigner. The assignee has rights equal to those of the assigner. An assignee has rights less than those of the assigner, or the assignee has absolute rights over the assigned debt. Which of the following are correct about the rights of an assignee under the Transfer of Property Act? Does the assignee have more rights or equal or less, or do they have the absolute rights? The correct answer is option B, that they have equal rights. So both the assignee and the assigner are going to have equal rights. For example, if a debtor has a counter claim against the assigner, then the right to receive the amount of the debt assigned will be subject to such claim, notwithstanding that the assignee has either no knowledge or the assigner definitely stated in the agreement that no claim will be raised. Alright, so both the assigner and the assignee are going to have equal rights. So the correct answer is option B. Next, which of the following is not a way in which goods may be delivered to the pawnee as per the Sale of Goods Act? So here we are talking about the Sale of Goods Act. So we know that the person whose goods are bailed is known as the pawner. So whose goods are bailed is known as the pawner. And then on the other hand, the person who takes the goods as security is known as the pawnee. They take the goods as security is the pawnee. Alright. So which of the following given here is not a way that the goods will be delivered? Handing over the key of the go down where the goods are kept, atonement by a warehouse man, handing over the document of the title to goods, immediate physical transfer of the ownership. So the pawnee is going to take the particular goods as security, but there are certain ways that this transfer can be made. Which of the following given here is not a way? So the correct answer is option D, that is immediate physical transfer. Immediate physical transfer is not a way. So the goods may be delivered by any one of the following ways: by handing over the key of the go down, by atonement, that is if the goods are in the public warehouse, then the warehouse man acknowledges the pawnee that he will hold the goods on behalf, handing over the documents of the title such as railway receipt, bill of lading, warehouse receipt. Another way is even if the goods are in possession of the pawner, he may acknowledge that he holds them thereafter on behalf of the pawnee. But the goods are not physically transferred. This transfer is only symbolic. Handing over of the key where the goods are scored, basically only symbolically it is done. Immediate physical transfer of ownership is not made in the case of the pawnee and pawner relationship or the bailee-bailer relationship. Alright, so the correct answer is option D. Next, regarding the pawnee's right against the third party, which statements are true? Now the pawnee is going to have some rights regarding the remedies for the legal implications of the pledge that are made, or who can make a pledge. So certain rights are there. Like the pawnee has the same remedies against third parties as the owner would have. The pawnee cannot take action against third parties. The pawnee's rights are limited to the original debt agreement, or the pawnee must involve the original owner to take action against the third parties. So, rights like the right of retainer is there, the right to claim extraordinary expenses are there. There is no right in retention of other debts, third parties, where the pawner makes a default in payment. So, the correct answer is option A, that is, the pawnee has the same remedies against the third parties as the owner would have. What are the rights of the pawnee against third parties? Same as the owner. That is, the pawnee's right where the pawner makes a default. Then, in case where the pawnee makes a default, the pawnee has three rights. They can either sue the pawner upon the debt or promise. They may retain the pawned goods as collateral security, or they can sell it off after giving the pawner reasonable notice of the sale. So, various rights are available with the pawnee once the pledge has been made. Alright, right against third parties as stated in the Morvi Mercantile Bank Limited versus Union of India case, they have the same rights as the owner would have if the owner is deprived of the goods. So they can sell off, they can sue the pawner, they can retain the pawned goods as collateral security as well. Then, what is the main advantage of a pledge of the pawnee? If a pledge is made, then what is the main advantage? So, the immediate transfer of ownership of goods, simpler formalities compared to a mortgage, ability to lease the goods to a third party, or there is no need for insurance. What is the benefit? So, what is pledge? We know that pledge means a bailment of goods that is made for the purpose of providing security for the payment of debt or the performance of a promise, which is under the section 172 of the Contract Act. So what is the benefit? The main advantage is that it has simpler formalities compared to a mortgage. The goods are in the custody of the pawnee and therefore it is easy to sell in the case of a default. In the case of mortgage, the mortgagee and the mortgager did not have these particular rights. If the banker takes proper precautions, it may not be possible for the pawner to create subsequent charges against the same goods. So if the banks they do follow the terms and conditions, then the pawner cannot recreate or they cannot again create charges on the same goods. Because of close supervision, it will not be possible for the pawner to manipulate the stocks. Even if the goods are unfortunately lost, the banker can recover the amount under the insurance policy. So, insurance policy is there in a pledge, and the formalities are simpler than in the case of a mortgage. Right? So, there are various legal implications of a mortgage, of a pledge, right? And only if the existing goods are in possession of the pawner himself, then only the pledge can be created. Possession of goods is the most important characteristic. So there are various benefits of a pledge over a mortgage. So there are simpler formalities, thus a pledge is preferred over a mortgage. All right. Next question. Which statements are true about the hypothecation as per the SARFAESI Act? SARFAESI Act is very important. Questions are asked from this act, and these questions are actually very scoring because SARFAESI Act contains simple conditions. So it includes a floating charge and a crystallization of such charge into a fixed charge on movable property. It involves transferring of the possession of the movable property to the creditor. It is a charge created by a borrower in favor of a secured creditor. excludes any future movable property. So regarding the SARFAESI Act, we are talking about hypothecation. This term actually came to be defined in the SARFAESI Act. What is hypothecation? It mainly means creation of a charge in, or we can say upon any immovable property. It can be either existing or in future, which is created by the borrower. So you can just remember it as creating a charge. I know you already know the meaning of hypothecation, right? So hypothecation means creating a charge on the movable property. Okay, and it does include the floating charge and the crystallization, which can be changed into the fixed charge. So the correct answer here, according to the SARFAESI Act, is option A, 1 and 3 only. It includes a floating charge and crystallization, and it is a charge that is created by the borrower in favor of the secured creditor. It excludes any future movable. No, it can either include existing or future, and it does not involve transferring the possession of the movable property. So it is a charge that is created by the borrower in favor of a secured creditor without actually delivering the possession of the movable property. So only a charge is created. It is hypothecated, but actual possession is not transferred to the creditor. So it is called as hypothecation, the mortgage of movable property. So whereby money is borrowed by the debtor on the security of the movable property without actually transferring either the property or the possession to the creditor, or we can say it is a charge against the property for an amount of the debt. So ownership or possession is not passed on. That is known as hypothecation under the SARFAESI Act. Next, which statements are true about an implied pledge and banker's lien? We know that there is an actual pledge and then there's an implied pledge. So which of the following statements are correct? A banker's lien is considered more than an ordinary lien and is regarded as an implied lien. The banker can recover any amount to the extent the lien is extended for negotiable instruments. The right to use the customer's money, funds and securities for repayment is known as the banker's lien, or a banker's lien does not apply to the negotiable instruments. So here we are talking about the charges that are created, or the interest or lien that a charge would be. So yes, the terms like charge, pledge or liens, they have to be correctly defined. They have to be registered. So here the correct answer according to the implied pledge and the banker's lien is option A, that is 1, 2 and 3 only. 1, 2 and 3 only. Here we can also make an calculated guess, right? We can make elimination. Why would the banker's lien does not apply to the negotiable instruments? It will apply to the negotiable instruments. Okay. So implied pledge means that lien is regarded as something that is more than an ordinary lien. It is an implied pledge. This distinction is not material in the case of negotiable instruments such as bills, notes and checks, as the banker is regarded under section 43 of the NI Act. The right of the bank to use the money or funds of the customer coming to its possession is known as the banker's lien. Banker's lien is the right that the banker has as to how they can use the money, the funds or securities that the customers are giving, or that the customers are providing to the possession of the bank. That is known as the banker's lien. So it is more than an ordinary lien. The banker can recover any amount, and it is the right to use the customer's money, fund and securities for the repayment. Alright, so option A. Next, according to the salient features of set off, when can the banker not set off the credit balance in a current account? Not set off. The question is asking us, when can the banker not exercise its power of setting off? So, set off means what? It basically means the right of the debtor to take into account a debt that is owed to him by the creditor, right? So, the banker has the right to set off, that will enable him to adjust a debit balance in the customer's account with any balance that is outstanding in the books of the bank, right? The banker can adjust the claim from the amount that is payable to the customer. That is known as set off. The banker is doing what? They are adjusting the amount from the account of the customer. So it is against a debt that is already paid, against the contingent liability of a bill discounted but not yet due, against any outstanding bills, or against an overdue loan. So where can the bank not set off the credit balance in a current account? If the credit balance is against a debt that has already been paid, or it is against a contingent liability, or it is against any outstanding bills, or against an overdue loan. So the correct answer is option B, that the banker cannot set off if it is against a contingent liability not yet due. All right. So we have already defined what is set off. What are the salient features? Both debts must be for certain sums. One, when we are talking about more than one debts, they should be for certain sums. The banker cannot set off the credit balance only if in the account till the liability of the guarantor is determined. Then the credit balance in the current account cannot be set off against a contingent liability, or if a bill discount is not yet due. The banker cannot set off a debt due to him upon a loan account repayable on demand. And the parties must be mutually indebted in the same right. So only in these conditions can the bank set off, and they cannot set off against a contingent liability. So the correct answer here will be option B. Next, what statements are true about the definition of a charge under the Companies Act? So charge is defined under the Companies Act 2013, right? Which of the following statement is correct about this definition? A charge can be an interest or a lien created on the property of a company. A charge includes a mortgage. A charge must be registered to provide security to the creditor. A charge deprives the company the ownership of the property. Does the charge really deprive the company ownership of the property? It is basically used to mean any form of security or debt, right? Charge is going to mean any form of security or debt. And interest or lien created on the property or assets of the company, of its undertakings. However, however, this is not correct, right? So an interest or lien created on the property of assets of a corporation or any of its undertakings. In other words, it creates a security on the property. No registration of the charge deprives the creditor the benefits. So here the correct answer will not be C, it will be A. 1, 2 and 3. 1, 2 and 3. It will not deprive the company of the ownership. So it is mandatory for every company to register with the registrar of the companies. They should specify the charges that are created by it on the assets that are owned. All this information has to be provided, plus the property of the company should be in good quality. It should be unencumbered, right? So the correct answer is 1, 2 and 3. Next, according to the Companies Act 2013, what right does the fixed charge give to the creditor? What right does a fixed charge give to the creditor? The right to transfer the ownership of the property, the right to sell the specific property through a court of law or tribunal, the right to lease the property to a third party, or the right to use the property for personal purposes. So which of the following rights are given to the creditor if a fixed charge is created? If a fixed charge is created. What is a fixed charge? It is also known as a specific charge on a specific property or properties of the company, right? When a particular property is given as a security for loan. So herein, it is going to provide a right to sell the specific property. The correct answer is yes, it is B. So it extends over a specific property or properties, specific property, then a fixed charge is said to be created. Under section 77, created in conformity with the provision, the right that is given to the creditor is that to sell the said property through a court of law or tribunal or under the provisions of the SARFAESI Act. It does not give a transfer of proper ownership or property to the third party or they use the property for personal purposes, but only if they have to sell the property through the court of law, tribunal or SARFAESI Act. Next, which statements are true about the crystallization of a floating charge? When we were studying the definition of the charge, we studied that a floating charge can be created and crystallization can be done. So what is true about this crystallization? A floating charge can crystallize when a receiver is appointed. The crystallization occurs only when the company continues its business operations. A floating charge may become fixed upon the occurrence of a specified event, or the crystallization can give the floating charge priority over subsequent equitable charges and unsecured creditors. So regarding the crystallization, which of the following is correct? So when will a floating charge become fixed or crystallized or attached? When the debtor company they cease to carry on the business or they are going into liquidation, or the debenture holder or the creditor they intervene by getting a receiver appointed, then we can say that the company they are disposing of the assets that are charged. This will change the floating charge to a crystallized or attached charge, right? So the correct answer here will be option D, that is 1, 3 and 4. Option 2 says it will be occurred only if the company continues. No, if the company is being dissolved or they're stopping their operations, that the crystallization will be done. If the business goes into liquidation or debenture holder in whose favor the charge is created is intervening and it is going to affect the powers of the company to dispose of the assets, then the floating charge can be crystallized. It can also be crystallized on the happening of the event that is specified in a charge deed. Right? So the correct answer is 1, 3 and 4. It cannot be crystallized if the company is continuing its business operations. Alright? So D is the correct answer. Next, under section 77 of the Companies Act, what is required when a company creates a charge? So when a company is creating a charge, which of the following will be required? Notification to the company shareholders when they are conducting a charge, they are creating a charge on its property. Should the notification be given to the company shareholders? Or registration of the charge with the registrar within 30 days? Or transfer of ownership of the charged property? Or the immediate payment of the charge amount to the creditor? I think this question is very simple, very direct. You can easily tell that registration of the charge with the registrar has to be done within 30 days. Right? They have to make a registration of the charge and there's a time limit. This time limit is 30 days. So the correct answer is option B. And this can be done through the e-form that the registration can be made. These forms were amended in the 2019 rules CHG 5, creation of the registration of charges and so on. Alright, so the registration of the charge with the registrar has to be done within 30 days. Next, which statements are true about the registration and notice of charge under the Companies Act? Again, question from the same topic. A registered charge give notice to any person acquiring the property from the date of registration. Any subsequent registration of a charge prejudices rights acquired in respect of any property before the right is actually registered. Does it make any prejudice? The registration of a charge does not affect the priority of charges. The charge registered first has priority over all the charges. So, if a company is making more than one charges, then which of the following is correct for the registration notice of charge under the Companies Act? Whether 1 and 4, 2 and 3, 1, 2 and 3 or 2, 3 and 4. The correct answer is that as soon as a charge is registered and a certificate is received, then it is presumed that any person that is willing to create a charge has received the notice of the charge. So statement 1 is correct. Also, it talks about that the charge that is created first will have priority above all the other registered later. So the correct answer is option A, 1 and 4. Alright, so as soon as the charge is created and a certificate is received, it is said that every person has been provided the notice. Alright, and also when the charge is created on a priority basis, the first one will have the priority as compared to the latter ones. Still, no prejudice has to be created. That any subsequent registration shall not prejudice any right acquired in respect of any property. Okay, so the correct answer is option A, 1 and 4 only. Next, according to Section 78 of the Companies Act 2013, who can apply for filing of the charge if the company does not register it within the specified period? So we have been told that registration has to be done within 30 days with the registrar. If, however, the company does not make the registration, then who can apply for the filing of charge? The company's shareholders, the company's directors, the charge holder or the registrar? I think you can simply answer this question. Yes, this section 78 provides that in the case that charge is not registered, then the charge holder may file the charge. The charge holder may apply for filing the charge in the prescribed manner, and the registrar may on such receiving of the application within a period of 14 days give notice to the company. All right, and any fees, if it has to be paid, it will be prescribed. So if the company does not register it itself, then the charge holder is going to make the application to the registrar. So the correct answer is the charge holder. Next, what is the maximum period allowed for intimation of payment or satisfaction to be made on the payment of additional fees? If a delay is made in the registration of the charge, then what is the consideration? Minimum period allowed: 100 days, 150 days, 200 days or 300 days. So charges, when they are created, fees has to be paid. So if it is done within 30 days, then normal fees will be paid. But if it is done after 30 days within 300 days, then normal fees plus additional fees will be created, right, beyond 30 days. So here the correct answer will be option D, 300 days. 30 days and 300 days on paying of additional fees. So section 82 provides that the company shall intimate the registrar for any payment, satisfaction in full charge, registration within a period of 30 days. Next, which statement is not true about the penalties under section 86 of the Companies Act 2013? Again, penalties is a very important topic, right? Regarding the penalties, which of the following is not true? The question is asking us not true. The company in default is liable to penalty of rupees 5 lakhs. Every officer of the company in default is liable to a penalty of 50,000. Any person who furnishes false or incorrect information is liable for action under section 447. The company and the officers are exempt from the penalties if the default is accidental. So which of the following is incorrect regarding the penalties? So the section 86 provides that if any company is in default in complying with any of the provision, then the company shall be liable to pay a penalty of rupees 5 lakhs. So this is correct. Then it also states that every officer of the company who is in default will have to pay a penalty of 50,000 rupees. And if the person willfully furnishes any false or incorrect information, then this and it is done knowingly, then they will be liable for action under section 447. But the company and the officers are not exempt from the penalties if the default is accidental, right? So the correct answer is option D. Even in the case of accidental default, they have to pay the penalty. They are not exempt from any penalty. So the correct answer is option D. And that is all. This was the last topic from our module B. We studied about the various acts under the module B, that is starting from the Prevention of Money Laundering Act, the Negotiable Instruments, FEMA, the Payment and Settlement Act for the creation and registration, charges, security, mortgage, everything we have covered. Now, um, I hope you would have understood the difficulty level of the questions, and you would now understand that yes, what are the areas where you need to give in more effort. You can improve your performance if you were not able to answer the questions. You can read these topics again from the notes that you have prepared, or from downloading the PDF. I've already mentioned, I've already given the detailed explanation of each and every topic. So what you need to do, tomorrow morning you'll download the PDF that I will provide. You will also find it in the description, plus in the Telegram channel. You will also find the PDF in the Telegram channel. Make sure that you go through it in the morning. You revise all the topics. And I will meet you again in the evening, same time, 9 p.m. with the third marathon session, and we will discuss the module C. All the topics, all the units, all the important concepts of module C will be covered in tomorrow's session at 9 p.m. Okay, so make sure that you revise. I will see you tomorrow. Okay, good night and all the best.